So, yes, you were under arrest. There's a warrant for your arrest.
Okay, pause right here. Before we go any further, you need to understand something. In criminal court, your bond conditions are basically a contract with a gun to your head. Break them, and that judge holds the trigger. Joshua here is about to find out exactly how sensitive that trigger is. Watch this.
And the police, the officers are going to get with you on this. Are you, you're Finland Falk? All right, Mr. Falk, you were charged here in 25 CR 122A with the second-degree felony of aggravated assault with a deadly weapon. Do you understand? Which carries with it up to 20 years in prison. Because this was handed
You
up
catch that
back
shift? The judge just hit the brakes hard. Here's why this matters legally. That positive test result? It's not just a piece of paper. It's preponderance of evidence that could revoke bond immediately. No trial, no jury, just gone. But here's the thing about lab results in criminal cases. They're only as good as the name attached to them. Question for you. Should judges verify identity before reading violations? Or is the system too overloaded for that luxury? Drop your take below.
in September by the grand jury. And this goes on to allege, though, that you were convicted of robbery 2 times in the 252nd District Court on the same day, May 24th, 2002, long ago. After those 2 convictions were final, it is alleged in the indictment that you committed the offense of illegal possession of a controlled substance, a 3rd-degree felony, and you were subsequently convicted of that on February 21st, 2019, also in the 257. So if all of this is true, you are looking at habitual felon status. No less than 25 years, no more than 99 years confinement in prison or life in prison is what you're facing. You understand? This is what the guy was facing yesterday in yesterday's trial, who got 55 years in prison.
Oof, that prosecutor just buried Joshua. He's using, said with the confidence of someone who's seen it 1,000 times. And honestly, statistically, she's probably right about most defendants. But this is exactly where confirmation bias kills justice. The system expects you to fail, which makes it so much harder to prove you haven't. The irony, she's about to be very, very wrong. Stay tuned for one of the most satisfying reversals you'll see in court.
You are under arrest at this moment. Do you understand? Yes, you are under arrest. There's a warrant for your arrest. And the police, the officers are going to get with you on this, and they will be able to talk to you about it. But this has popped up, and you got to answer for it. We're gonna make a copy for you so you can have a copy of it. But your bond is revoked due to this warrant. And what was his bond before? What was your bond on this?
I think it was 20,000.
20,000 for habitual felon and committing aggravated assault.
Judge, I believe the issue here is the case was filed and dismissed, and I believe he bonded out on that first filing. And when it was dismissed, there was no warrant, and he didn't bond out on the new indictment. So I believe that's what's happening today.
That's correct. He has no bond.
There it is. The moment everything flips. Notice how fast the energy changed? 30 seconds ago, Joshua was looking at immediate jail time. Now, the judge is scrambling. This is what due process actually looks like in real time. Messy, human, and terrifyingly fragile. If that clerk had double-checked the name when filing, this never happens. One keystroke error nearly cost an innocent man his freedom. Let that...
On this new indictment. So it's just a make bond.
So,
I don't find this bond enough at $25,000 anyway. Who said the bond?
so
But you are a habitual felon, sir, and these are two prior violent crime convictions and then a serious illegal possession of a controlled substance. And now this is aggravated assault by threatening to use a deadly weapon, namely a vehicle. So your bond is increased to $100,000. There's a way to avoid.
Full transparency. This apology is rare. Most judges would double down, find some other reason to be angry. The fact that she owns it and explains why she was triggered actually shows solid judicial temperament. But here's the uncomfortable question. Would this apology have happened if Joshua hadn't pushed back? If he'd just accepted the violation silently, like so many defendants do? The power dynamic in that room just completely inverted. Notice how she's now the one justifying herself.
All of this is to not to commit crimes. And if you post a bond, you will be at home confinement. You must have a GPS device. You cannot leave the home except to and from work, most direct route possible, to and from hospital care, to and from acquisition of food. And those are the other purposes. And that's the way it is. Do you have an attorney?
Also,
All right. Are you unable to hire somebody? Fill out an indigent form and an attorney will be appointed to represent you. We'll appoint somebody today from the public defender. You're taken into custody. That's the rulings of the court. No, sir. Sir, your bond is too low. Sir, you are a danger to the community. Your bond is far too low under the circumstances that we have. Plus, there's a warrant for your arrest. And it's not a debate, sir. Follow the rules of the court. Thank you.
We'll just get her to fill out the form for the jail.
Next is Jaquan Lazard. Next is...
As to the assault battery, how do you plead?
Your Honor, I'm sorry to interrupt the court. It was brought to my attention that I had put a little bit of a different offer in writing to Mr. Carter. I don't know if I did that inadvertently, but I will honor that. And that would mean that would change it to him pleading to still the added count of an attempt R&O with dismissal of the balance of charges.
Well, he didn't know that. You didn't know that? I'm asking him. You can't tell me what he knows. I'm talking to him. You didn't know that?
Yeah, I did.
So why you ain't say that? And when I said if that's your understanding of the offer, why you say, Judge, that's not what they told me?
No.
You don't think you got to protect yourself out here?
Yeah.
You got to do better. You got to get a belt and you got to protect yourself.
Okay.
You understand that?
Definitely.
Okay, so we're dismissing the assault battery?
That is correct, Your Honor. I apologize.
No worries. As to the attempted resisting obstructing officer, how do you plead?
Yes.
And that's because you believe you're guilty of that?
Yes.
Are you sure?
Yeah.
Factual basis.
Mr. Robinson, on or about December 15th of 2025, were you in the city of Lansing?
Yeah.
Ingham County?
Yeah.
More specifically, 3933 Phoenix Drive?
Yeah.
And at that time, did you come in contact with police officers as they were investigating a call that they received?
Yes, ma'am. Yeah.
And at that time, were you in a altercation with a Mr. Johnson?
Yes.
And the officers gave you commands to stop and you did not immediately stop?
Yes.
And they actually ended up having...
Joshua caught a break, literally a clerical break. But here's the final legal insight most people miss. That $3,000 surcharge the judge waived? That's part of a massive DWI industrial complex. These cases generate billions annually in fines, interlock devices, monitoring fees. The system needs people to reoffend to stay profitable. Joshua's walking out, but he's walking into a machine designed to pull him back in. The real question isn't whether the judge was too aggressive. It's whether any system this reliant on administrative accuracy can be trusted with people's lives. Hit subscribe if you want to learn how to protect yourself from exactly this kind of nightmare. See you in the next breakdown.
to say that coming more than one time, isn't that correct?
Yes.
And you refused to do it at first, correct?
Yeah.
I have nothing further.
People are satisfied.
The court is satisfied with the factual basis. I'll accept your plea. I find your plea to be freely, voluntarily, and intelligently made. This matter is scheduled for sentencing March 6th at 9 o'clock in the morning, okay? We're gonna go downstairs and check in with probation for you leaving today, and they'll get you scheduled for a pre-sentence interview. You have any questions at this time?
No.
Any additional matters?